My firm has handled M&A transactions with a total deal value of over $1 billion. And in that time, I've seen legal fees on startup exits run anywhere from $25,000 to over $500,000. That's a realistic range too. And because a ton of people ask me how much a lawyer costs when it comes to M&A deals, I wanted to make this video to explain why the range of legal fees is this wide, what determines where you land in it, and what you're actually paying for when you hire legal counsel to handle your exit. By the end of this video, you'll understand where every dollar of your legal bill comes from and how to make sure you're not overpaying. Let's get right into it. What legal fees actually look like? To start off, I want to emphasize that legal fees in an exit don't have one number, and I'm going to show you exactly why. The $25,000 to $500,000 range comes from tracking over 100 real transactions. Those numbers are that far apart because no two deals are structured the same way, and the differences between them directly determine how much legal work is involved. Before I get into what moves the number, it helps to start with some concrete anchors by deal size so you have a baseline to work from. For the deals in the single-digit millions, a boutique firm will typically charge you somewhere between $15,000 and $40,000. $25,000 to $40,000 is roughly average on a $5 million deal for a boutique firm that's handling it end to end. $15,000 is the low end. That's a clean deal, smooth process, minimal back and forth, and a client who doesn't need a lot of hand-holding along the way. $50,000 is the upper end for that same deal size, where the firm is in on essentially everything: negotiations, due diligence, questions, ancillary docs, and filings. The difference between $15,000 and $50,000 on the exact same size deal comes down to how complicated the deal gets and how much the process drags, which I'll get into later. A practical benchmark for mid-market boutique lawyers is 0.5% to 1% of the transaction value. That gives you a quick way to estimate legal fees as you're thinking through your total transaction costs. On a $10 million deal, that's $50,000 to $100,000. On a $25 million deal, you're looking at $125,000 to $250,000. And these are estimates because complexity can push the number in either direction, regardless of deal size, or the transaction could cost less. Now, big law is a completely different conversation. At large firms, attorneys charge anywhere from $1,000 to $2,000 per hour. So on a single-digit million-dollar deal, that can mean legal fees well over $200,000. It's important to remember that a firm whose average deal size is 100 times your deal size will staff your deal the same way they staff their biggest transactions, which drives your bill up significantly, but your deal is still the smallest thing on their plate, so it doesn't get the same level of attention or urgency. So you end up paying big firm rates for a deal that isn't priority to them, and that combination is what makes it a bad fit. So right sizing your legal team to your deal is one of the more important decisions you'll make in this process. And if you're watching this and you want to know what your specific exit would actually cost in legal fees, click the first link in the description to book a free consultation with me. Every deal is different, so in that call, we can go through your specific situation and give you a real number to work with. But let's keep going. How legal fees are structured. Now that you have a sense of the numbers, it helps to understand how lawyers actually charge for this work, because the structure matters almost as much as the rate. The most common structure is hourly billing. For example, my rate as a SaaS lawyer is $650 per hour, which sits right in the middle of the market. With hourly billing, your final number depends entirely on how long the deal actually takes, which is why understanding what drives timelines is so important. And I'll get to that in just a bit. The second option is milestone-based flat fee payments, which a lot of founders prefer because it removes the uncertainty. Here, the fees get broken into defined stages: LOI signing, sending the purchase agreement, completing due diligence, signing the purchase agreement, and closing. You know exactly what you're paying at each stage, so there are no surprises when an invoice shows up. For founders going through this for the first time, that predictability is very valuable. Some lawyers also offer fee caps, which put a ceiling on your total exposure regardless of how long the deal runs. A $40,000 fee cap means once fees hit that number, the lawyer stops billing even if the deal keeps going. This protects you specifically in situations where the process drags on for reasons outside your control, which does happen more often than founders expect. There's also a blended model that combines a discounted rate with a cap. This gives you some cost predictability while still tying fees to time actually spent. The right structure for you depends on the deal, the lawyer, and your own appetite for cost variability. Beyond legal fees, there are a few other costs worth having on your radar as a seller. M&A broker or investment banker fees range from 2% to 15% of the transaction value depending on deal size, and many brokers also charge a monthly retainer between $5,000 and $25,000 on top of the success fee. Then there's quality of earnings, which is an intensive financial due diligence process that analyzes the quality of your revenue. It typically runs $20,000 to $50,000 or more, but the buyer typically covers quality of earnings as part of their own diligence, though some sellers choose to get it done ahead of time. What actually drives legal fees up or down? So now that you know how fees are structured, let's talk about what actually causes the number to move once the deal is underway. The single biggest driver of cost that founders underestimate is who ends up on the other side of the deal. If the buyer's lawyer doesn't have real M&A experience, they will slow the process down in ways that are completely outside your control. Lawyers without M&A fluency tend to over-negotiate points that don't matter, flag non-issues, and add unnecessary friction to the timeline. And a longer timeline means higher legal bills for everyone, no matter how your fees are structured. We had a deal recently where this played out directly. We were representing the seller, and the deal was supposed to close in 60 days. But midway through, the buyer brought in a second attorney for another opinion. And that second opinion resulted in the entire purchase agreement being rewritten at the point when we were already supposed to be at the closing table. A 60-day deal ended up taking 150 days, and legal costs for everyone involved went well beyond what anyone had planned. The buyer's own experience level feeds into this as well. In that same deal, the buyer didn't have a clear sense of what actually mattered in the negotiation, so they spent time going back and forth on every minor point out of inexperience rather than strategy. They kept pushing the closing date back, and at a certain point, the seller had completely lost confidence in the buyer. So we had to draw a line. We close now or we walk. Now, deal complexity is the other major cost driver, and it's one you have more visibility into up front. An all-cash deal with clean documentation costs significantly less than one involving a rollover, multiple classes of investors, an SBA loan, a seller note, escrow agreements, employment offer letters, and real estate leases. More moving pieces means more documentation, more negotiation, and more hours billed. And a $20 million deal can sometimes be more simply structured and easier to close than a $2 million deal. So deal size alone doesn't tell you much about complexity. Several other variables move the number as well, like how much involvement the client wants throughout the process from the lawyer. Some founders want to be looped in on everything. Others are more hands-off, and that difference shows up in the bill. The M&A broker's level of involvement comes into play also. When the broker is actively supporting the negotiation and everyone can work as a team, it takes pressure off legal counsel and keeps the deal moving forward. Then there's how much experience the seller has with complex transactions. The less familiar you are, the more guidance you'll need, and that time adds up. Lastly, whether the financing gets complicated. Lenders can throw unexpected issues into a deal mid-process, and when that happens, everyone's timelines and legal costs take a hit. Now, why these costs are worth paying? With all of that being said, the right way to think about legal fees in an M&A transaction is risk mitigation, not just the transaction cost. A good attorney isn't only drafting documents. They're identifying risks that could cost you far more than the legal bill itself, both during the deal and after it closes. One concrete example is the holdback clause. A holdback means if something goes wrong with the acquisition after closing, the buyer will retain a portion of the purchase price as protection, typically 10 to 20% over a period of 12 to 36 months. Some buyers use this as a way to chip away at the cash paid at close and to provide more protection for themselves, because if something goes wrong after the deal closes, the buyer will include a provision called a set-off, where they can deduct costs from the holdback to reduce the amount they pay you as the seller. So you want to make sure to work with your lawyer to draft these clauses and the reps and warranties carefully. Another example is protecting yourself during the due diligence process itself. When an acquirer approaches a founder with a large number, it's easy to get excited and open up about everything. What can happen is the buyer does a full deep dive on your business, sometimes going as far as a complete review of your tech infrastructure, and then they pull out of the deal entirely. But with legal counsel involved, from the start, you have someone controlling what gets shared and when, so you're not just handing over sensitive information before a deal is actually locked in. Choosing the wrong lawyer is also a real financial risk that founders don't always factor in. Hiring a generalist or your regular corporate attorney to handle an M&A transaction, even if they're excellent at what they normally do, leads to a less efficient process, a higher chance of the deal falling apart, and more legal exposure after closing. A lawyer charging more per hour who knows M&A well can end up costing you less overall than someone cheaper who doesn't. And if a firm is used to handling billion-dollar transactions, they'll approach your $25 million deal the same way, and the bill will reflect that. So if you're a founder thinking about selling your company and you want to understand what your legal costs and exposure actually look like before you start any conversations with buyers, click the first link in the description to book a free consultation with me. We'll go through your specific situation, walk through what the exit process looks like for your deal, give you a clear picture of what your legal costs would actually look like, and make sure you have the right legal foundation in place before anything gets started. Again, that will be the first link below this video. And if you're looking for clarity on how to even go about selling your startup in the first place, then check out this video next.